Okay, let's make a start. Good morning, everyone. Welcome to this update on data protection and freedom of information for higher education. My name is Andrew Gallie, and I head the data protection and information law team here at VWV. And it's really great to be speaking to you all this morning about data protection and freedom of information. So we're going to spend the next hour or so looking at some key information law topics. As ever with these things, it's a mixture of looking at some of the things that we've been advising on recently, sharing some practical tips, but we'll also look at the latest legal developments in particular. As I'm sure you're all aware, most of the changes introduced by the Data Use and Access Act are now in force, and so we'll be looking at what those changes mean for data protection law in particular. Now, although the session covers both data protection and freedom of information, the feedback that we get, and also just in terms of the queries we get, is very much that people are much more interested and worried about data protection than freedom of information. So most of what I say will be on the data protection side. If you have any questions, please do drop them into the Q&A box, and I'll do my best to answer them at the end of the session. I'm going to try and finish slightly earlier than previously, just to leave a bit more time for questions. If you have a technical problem, then if you could put that into the chat box, and one of my colleagues will look into that for you. So, could the next slide, please, Evie? So, in terms of what we're going to cover off today, I'm going to start off by sharing some tips around subject access requests. I'll then look at some points around data and cybersecurity. We'll then share some insights on managing freedom of information requests. We'll look at sharing personal data for research, international data transfers, and then we'll finish off with some thoughts on the new obligation to have a data protection complaints process. Could I have the next slide, please? But before we dive into the detail, I just want to sort of pause for a moment and just sort of take stock on where data protection law sits generally. So I mentioned a moment ago that the Data Use and Access Act changes are now mostly in force. And this is really the first material change to data protection law since GDPR started to apply around 8 years ago. It amends all aspects of data protection law. So just by way of reminder, when we're talking about data protection law, we really mean three things. We mean the UK GDPR, which contains most of the rules, the 7 principles and so on. The Data Protection Act, that contains most of the compliance exemptions, and PECA, or the privacy regulations, which contain the rules around electronic marketing. And so the Data Use and Access Act amends all three. Whilst that's the case, it really is very much a small course correction rather than sort of a wholesale change in your obligations. And it's really probably the first time ever we've got data protection law that in many respects sort of seeks to roll back some of the compliance obligations rather than make things more onerous. So it's trying to sort of chart a bit more of a pragmatic path, and we'll look at some examples of where that's the case over the next hour. The Data Use and Access Act changes, it's really a mixture of putting of new things, so new ideas, and also putting some of the ICO guidance onto a statutory footing. So some of the changes reflect what's been in ICO guidance and indeed in case law for a number of years. The ICO are in the process of updating their guidance to take account of the Data Use and Access Act. So they've introduced new guidance on subject access requests, international transfers, and then most recently they've put out some new guidance, draft guidance for consultation on using personal data for research. The vast majority of the data protection changes introduced by the Data Use and Access Act are now in force. They came in on the 5th of February with virtually no notice. The only thing that's really outstanding is the new rules on complaints aren't set to apply until the 19th of June. So there is a bit more time to prepare for that. So you've got a bit of time if you're sort of updating your complaints paperwork and so on. And as I mentioned, we'll look at what the new rules on complaints mean in practice towards the end of the session. So whilst most of the new stuff is really focused on the Data Use and Access Act, there's other stuff going on. So the Cybersecurity and Resilience Bill is working its way through Parliament, and that will require some organisations to have heightened measures in place around cybersecurity. It probably won't directly affect HE, at least initially, but we'll cover that off briefly in a few minutes' time. Okay, so let's get into the detail then. So next slide, please. So I want to start off then with I guess everyone's favorite topic, subject access requests. On the next slide, please, Evie. So certainly based on sort of what comes across our desks, this is probably the area of data protection compliance that gives people the biggest headaches. It's what we advise on most. We've got 8 people on the data protection team, data protection information law team, and a couple of those advise almost exclusively on subject access requests. So I just thought I would share some practical tips, including some points that have arisen out of the Data Use and Access Act changes. So if we are sort of asked to advise on a subject access request halfway through, what we often find actually is that the first thing that sort of jumps out of us, so if the client's already started and we're sort of asked to sort of get involved once the process has started, is we often find that people actually do far more extensive searches than they are legally required to do. Um, it's been the case for years and years that your obligation is to do a reasonable and proportionate search only. And that's now on a statutory footing following the introduction of the Data Use and Access Act. And so what does that mean in practice? Well, it does not extend to sort of searching every single location on the off chance it might contain disclosable personal data. If, for example, you had an employee who's worked for you for many, many years, they make a subject access request, they're not particularly helpful in terms of sort of telling you what they want. They don't sort of refer to anything specific. I would really be focusing on their HR file and any of the sort of key systems where you hold their data. Maybe speak to the line manager and maybe do some targeted keyword searches to reflect particular flashpoints or issues. There is no legal obligation under data protection law to do sort of the sort of really extensive keyword searches that we sometimes see. So you don't have to do that, assuming that you can justify what you've done as being reasonable and proportionate. The other point is this is I'm sure we've all seen subject access requests where the requester seeks to dictate terms. So they say, I demand you search all these things. They provide like a whole page of keyword searches. There's no legal obligation to do that. Again, it's your decision as the controller in terms of what keyword searches that you do. Um, it's it should also be noted that you don't actually have to tell the requester what keyword searches you've done, although sometimes maybe doing so can be helpful if you think that would sort of help reassure them if you have decided to do the searches that the individual requested. So you can also seek clarification on a subject access request. Until recently, you had to demonstrate that you processed a lot of information before you sought clarification. The lot of information prerequisite has gone, which means that but you still got to sort of be reasonable in terms of seeking clarification. So do you reasonably require further information to identify the personal data or processing activities that the request relates to? So when might you seek clarification? So it might be, for example, if the request is unclear, if the individual has interacted with you in various different capacities, for example, if they've been a student and a member of staff. As we all know, SARs are often made in the context of wider grievances, complaints, disputes, claims, whatever it might be. And so if the request has already got lots of information as part of the wider process, you might ask them, well, actually, what else do you want? Bearing in mind the volume of information that you've got. One of the tactical advantages of seeking clarification is obviously that the clock pauses. So it buys you a bit more time to provide the response. Now, the Data Use and Access Act has clarified that the pause, when you pause the clock is paused both on the day that you seek the clarification and the day that you receive the response to the clarification. So let's say, for example, you seek clarification at noon on Monday and you get the clarification response back at noon on Thursday. To my mind, that looks like 72 hours, but you actually get back 4 complete days in terms of how long the clock has paused for. This also means that if you seek clarification at noon on Monday and you get the response at 1 minute past 12 on the same day, that buys you back a whole day essentially. Um, the ICO didn't quite get this right when they published their guidance, the new style guidance back in December. And I believe last time I checked, the PDF version of the ICO guidance hadn't been updated to reflect the true position. So if you're wondering how what I'm saying aligns with ICO guidance, it's if you're using an older version of the new guidance, then it might not have been updated to reflect the true position there. So quite often what you'll find is that you seek clarification and the requester says, no, I still want absolutely everything about me. The ICO's position has always been that you should still do a reasonable and proportionate search, notwithstanding the lack of clarification. But there's there's some interesting language used in the Data Use and Access Act on this point. It says essentially that the clock doesn't unpause until the requester provides the information, the clarification information that you've requested. So this so it could therefore be argued that if the requester doesn't provide meaningful clarification, the clock never unpauses and you don't have to respond to the request. Interestingly, the ICO in its new guidance have kind of sort of skirted over this point a bit, but they say even if the requester doesn't provide meaningful clarification, it says you should still do a reasonable and proportionate search. But it's interesting the ICO say should rather than must. So it does appear to allow for some flexibility. And it may be that if you want to adopt a particularly adventurous approach to the style that you could sort of refuse if you, in the absence of meaningful clarification, but obviously that's not without risk. So you can refuse a subject access request outright if it is manifestly unfounded or excessive, and it's obviously a high bar before you sort of go to the trouble or you go to the point of refusing a SAR outright. Manifestly unfounded, it might mean, for example, that if the requester has no interest in their data, they are, for example, just making a subject access request to obtain information to make sort of defamatory comments about staff and so on. If it's excessive, if you're getting lots and lots of overlapping requests. But it's nevertheless a useful tool to sort of have it in your back pocket. And there might come a point where, look, you think if you've got sort of multiple requests that you start to refuse them. For example, I was advising a client last year where individual had made a claim. They made a subject access request in the spring, in the summer, and then one followed in autumn, and the client refused the autumn request on basis it was manifestly unfounded and excessive. Partly because it overlapped with the previous request. It was obviously being made to fish for information to support litigation, and there are separate litigation processes, separate processes for disclosure of documents under litigation. So it's something to bear in mind as well. And then we're also getting lots of requests or lots of queries about to what extent you have to sort of search outside of your core systems. For example, people when making requests might say, I want you to search people's sort of personal WhatsApps, text messages, whatever it might be. And again, it comes back to what is a reasonable and proportionate search. And you don't need to be sort of searching non-core systems unless you have good reason to believe that they hold disclosable personal data. For example, if someone says, can you search sort of private WhatsApp messages between these two members of staff, if you've got no reason to suspect there is disclosable personal data within those platforms, then you don't need to do it. And in this regard, I think it's really important to make sure that your policies are really, really clear on what systems staff can and can't use to sort of to share business-related information, because that would also support your justification if you were ever challenged regarding what sort of systems, what platforms were searched or weren't searched. Okay, can we have the next slide, please? Okay, so and I want to move on and talk about cybersecurity and data security. Can we have the next slide, please, Evie? So this is, I think pretty much since we started sort of doing these webinars 10, 15 years ago, we've talked about data security every time. And the reason is simply, it is one of the areas of greatest risk in terms of data protection compliance. The vast majority of ICO fines, compensation claims from individuals stem from data and security breaches. So it's a really important area of compliance to get right. The GDPR, interestingly, says very little about data security. It says you've got to put in place appropriate technical and organizational measures to safeguard personal data. So technical measures include things like network security, using appropriate encryption and so on, organizational measures, staff training and policies and the like. So as I mentioned, there isn't very much detail in the GDPR itself around what counts as good security. There's a lot of ICO guidance though, and there's also a lot of guidance from the National Cyber Security Centre. So the NCSC was a body set up in 2014 to provide advice and assistance to UK organisations on cyber risks. And there's loads of sort of technical guidance on the website. There's also tools. For example, you can apparently sign up to a service where you will be told if your network's been compromised. They also have cybersecurity training modules that you might want to incorporate into your existing staff training. The other reason why it's important to pay close attention to what the NCSC says is, as many of you will know, the ICO will sort of benchmark an organization's compliance against NCSC guidance. So if you've suffered a data breach and the ICO find that you weren't following NCSC guidance, that really does increase the chance and the prospect of regulatory action. Okay, so I mentioned at the start of the talk there is there's new cybersecurity legislation making its way through Parliament, and this is in the form of the Cybersecurity and Resilience Network and Information Systems Bill. So just a little bit of context to this. So the bill will, amongst other things, update the Network and Information Systems Regulations, or NIS for short. So the NIS regulations came in 2018, and they required certain organizations to have heightened data and cybersecurity measures in place. So they apply to operators of essential services above certain thresholds in sort of core sectors, such as the NHS, the energy and transport sectors. And they also have requirements for digital service providers, again, above certain thresholds. For example, certain cloud service providers. And NIS covers both sort of cyber risks, but also physical risks as well. For example, risks around sort of damage if your sort of servers are sort of knocked out in a flood. So the new bill is set to sort of update and amend NIS. It will also require it will also bring additional organizations within the scope. For example, managed service providers will now be subject to the rules. So going forward, if you're sort of appointing a managed service provider as part of your due diligence, I would suggest that you should be checking whether they are subject to the new rules, and if so, sort of checking that they comply with their obligations. Um, so universities themselves, universities HE probably won't be caught by the new rules, but it's possible they will be further down the line. For example, um, operators of essential services caught by the rules can designate certain third parties as critical suppliers. And where that's the case, those third parties then have to comply with the heightened rules. So let's say, for example, there was another pandemic. A university developed a fantastic diagnostic platform that was used by the NHS to sort of screen, triage, diagnose patients. It's possible the NHS would designate that university as a critical supplier to sort of preserve the security of the platform. Um, the government also has a wide power to bring other organisations within the ambit of the regulations through further regulation. So again, it's possible at the government side that more organisations going forward will be subject to the rules. So really something just to be aware of at this point in time. It probably won't affect you directly, but it just shows, I guess, the direction of travel and the fact that the government is sort of focused on and concerned about cybersecurity, which is obviously a good thing. And then my final point on the slide is this: is so the government has consulted on a public sector ban on making ransomware payments and a requirement to require the private sector to seek permission before paying ransomware. Now, it had been mooted that these new provisions would find their way into the new bill. That hasn't happened. Excuse me. But it's quite possible then that there'll be separate legislation in due course, sort of setting up new rules around making ransomware payments. But to be honest, in a lot of sectors, there's already a de facto ban. So to what extent it would make a difference, I'm not sure. Okay, can we have the next slide, please? So just to summarize then, in terms of key risk areas to focus on, I'd be looking at your staff training and policies. I'm sure most of you have been unfortunate enough to have to complete an ICO data breach form. And of course, you have to tick a box to confirm staff have been trained in the past 2 years. If you can point to a something in your policies that says don't do X, and the member of staff did X that led to the breach, and that obviously is a significant mitigating factor in your favour. Also be thinking about vendor management. So if you, as well, I'm sure you all use suppliers to sort of you trust suppliers with your personal data. Make sure that they are handling the data in line with data protection requirements. The vast majority will be a data processor. So make sure you've got that compliant controller processor contract in place. Do the due diligence on their security, on their compliance. You can also get sort of third-party tools to help you sort of assess a potential supplier's security posture. That will sort of do a report for you on sort of where they sort of stand in terms of their data protection and cyber security. And if you've taken all these steps and the supplier has a breach, you're much less likely to be exposed to fines and other regulatory risk. So obviously we're talking about personal data here, so the focus is very much on sort of data protection, on personal data, but don't forget that you will have sort of other information that you want to protect. So it might be, for example, that what your supplier, what your partner has access to isn't actually personal data, it's information that is perhaps commercially sensitive. So don't forget to include appropriate security provisions in contracts, even if there isn't a strong data protection element. I wouldn't necessarily sort of suggest you should be relying on sort of the boilerplate confidentiality provisions that we've all seen in contracts. So think about whether you need to sort of include any sort of extra provisions around cybersecurity, around sort of data management, um, to protect information that is commercially sensitive. And those provisions might, for example, sort of mirror some of the provisions we sometimes see for personal data. For example, requiring them to sort of to comply, to have the appropriate technical measures, appropriate organizational measures in place to safeguard personal data. And then very finally, my final point here, so quite often suppliers will make all sorts of really fantastic commitments around their compliance, around their data security. For example, that they'll promise to be ISO certified, around the type of encryption they use. If you can, uh, make sure that those commitments are put on a contractual footing. For example, that they appear in a schedule to your contracts of setting out what they're going to do in practice. And that way, it's much easier to have a contractual claim if they don't meet those commitments or if something goes wrong further down the line. Okay, can we have the next slide, please? Okay, so I just want to change tack briefly and share some thoughts on and share some insights on freedom of information requests. For the next slide, please. So we're getting a lot of queries about when freedom of information requests can be refused on the ground that they are vexatious. And just by way of reminder, under Section 14 of FOIA, you can refuse a request if it is vexatious. The leading case on this is still the Dransfield litigation from 10 years ago or so, where the upper tribunal essentially laid out four indicative criteria that might point to a request being vexatious. And those were the burden of the request on the public authority and its staff, the motive of the requester, the value of the request, and to what extent the request was causing harassment or distress. But the case very much emphasised there is the only sort of indicative sort of criteria, and you should be looking at the whole context when deciding whether or not a request is vexatious. And in that regard, I would sort of look at the full context. So often there is an awful lot more going on than simply a FOIA request that might seem vexatious. For example, an individual might be making freedom of information requests as part of a wider campaign or dispute with yourselves. They might be making complaints. They might be making lots of subject access requests. And those sort of wider contextual factors are all factors you can take into account when deciding whether a request is vexatious. And I would also keep a record of your interactions with the individual. So if there comes a point where you think we want to sort of start refusing requests because they're vexatious, it's so helpful to have sort of a almost like a timeline or a record of your interaction. So you've got sort of the evidence that you need there and then. We're also finding that a lot of organizations are leaving things too late. And I just want to quote from the ICO guidance on vexatiousness, if I may. So the ICO say, although satisfying Section 14.1 is a high hurdle, this does not mean you can only apply it in the most extreme circumstances or as a last resort. You should consider using it if, after taking account of all the circumstances, you believe the request is disproportionate or unjustified. So the key there for me is it is not a last resort. And I've seen a few public authorities come a cropper because they kind of leave it too late. So they get to the point essentially where the individual has almost sort of overrun them with so many requests or the nature of the request such that they start making mistakes, they start missing deadlines. And at that point, it's harder, although of course not impossible, to sort of argue that requests are vexatious if you're in a situation where you're starting to sort of where you've got some compliance issues with how you've handled the previous requests as well. So, just in terms of compliance, in terms of strategy, if I would be going in earlier rather than later where you can, in terms of saying requests are Vexatious. Um, Another query I was asked recently, should public authorities proactively publish FOIA requests, for example, on their website? So here what I'm talking about is should you publish the request rather than should you publish um, the the information that you shared with the requester? And I would urge caution. So I've seen a case where a member of the public made a FOIA request that was sort of laced with potentially defamatory comments about various people. Public authority published it, and then potentially they're then exposing themselves to various claims as well. So I'd be cautious before doing that. Um, don't forget the environmental information regulations. So there's also a temptation just to focus on the Freedom of Information Act, but some requests will fall to be dealt with under the environmental information regulations, which I'm sure many of you will know, will sort of broadly similar to freedom of information law with some differences. They apply to environmental information, which is defined very, very broadly in the regs. So always sort of checking your minds, your sort of mental checklist, should this be dealt with under the regs rather than under FOIA? For example, if it relates to asbestos issues, to sort of old dilapidated buildings that might have an environmental issue, whatever it might be, just keep the regs in the back of your mind. Okay, can we have the next slide, please? Okay, so moving then back to data protection considerations. So using personal data for research. Next slide, please, Evie. So just by way of reminder, data protection law relaxes some of the compliance rules if you are using personal data for research-related purposes. And by research-related purposes, we're of course talking about using data for historical research, for scientific research, archiving the public interest, and statistics. And one of the perceived problems with the current data protection legislation is that the rules on research are kind of scattered around various different points in the Data Protection Act and in the GDPR. So one of the things that the Data Use and Access Act has done is to consolidate a lot of the provisions into one place. So most of the research provisions can now be found in Articles 84A to D of the UK GDPR, but there are still provisions that are sort of you still need to sort of check elsewhere for some of the provisions, for example, the definitions and some of the points around data subject rights. So in addition to sort of reordering the provisions, the Data Use and Access Act has also amended and relaxed some of the requirements around using personal data for research. So, and some of those relate to consent for research purposes. Now, as you all know, if you do any processing of personal data, you need to make sure that your processing falls under at least one of the 7 lawful bases set out in Article 6 of the GDPR. And one of those lawful bases is consent. So you can use personal data. You can use consent as your lawful basis for processing personal data for research purposes. But just to clarify, in research, you get some different types of consent. So you may have consent to use personal data for research, but you've also got sort of consent, ethical consent, or consent, or you might get consent from people for them to take part in the research. That's completely separate. We're not talking about those types of consent. We're just talking about GDPR consent. And one of the problems with getting GDPR consent for research is at the time when you're seeking that consent, you might not actually know in what direction the research project will go in, or exactly what the personal data will be used for. So the Data Use and Access Act has relaxed the consent requirement such that it still counts as valid consent, even if you cannot fully identify the research purpose within the umbrella of scientific research at the time the consent is sought. So if you're getting consent for scientific research and you're not quite sure what it's going to look like, the research, then that won't necessarily be a bar to getting consent. So again, that's helpful, but I suppose there's a wider point here, which is this, which is why would you bother getting consent to use personal data for research? And that's because there are lots of alternative lawful bases in Article 6, such as legitimate interests, public task, that will sort of that should serve you well. Equally, if you're processing special category data, for example, health data, there is a explicit processing condition for research in Article 9. And the problem with getting consent for research is, as I'm sure you all know, people have a right to withdraw that consent. So if you get consent, you start using the data for research, they withdraw their consent, you're kind of stuffed because you can't then use carrying on using that personal data as part of the research project. And that it might be quite difficult to sort of to extract the personal data if the research project has already commenced. So perhaps more helpfully, the Data Use and Access Act has also relaxed some of the requirements around transparency, around the privacy notice obligations. So essentially, it gives more room um, to reuse personal data um, for research purposes. So if in a position where your original privacy notice didn't mention you might use data for research, that's no longer fatal. Uh, uh, but you've still got, if sort of providing a new privacy notice would be disproportionate or would be impossible, but you should still, for example, be putting the privacy notice on your website, the updated notice that people understand, people can see that that using their data for research purposes. So the ICO has updated its, as I mentioned at the start of the talk, the ICO has updated its guidance on research. It's out for consultation. I don't think there's too much in that that's new, but it's worth. But there's some interesting stuff around what counts as scientific research. So the ICO have got a new way of looking at that. So it's well worth having a look at that. But that aside, I think it's kind of just reflects the existing ICO guidance for the most part. And then my final point on the slide is this, and this actually doesn't relate directly to research, but it's kind of there's kind of an overlap. Really, since GDPR came in, there's been a debate about if you share personal data, de-identified personal data, is that still personal data in the hands of the recipient? So to give you an example, if you use personal data for research, you then um, you then sort of make that research available to third parties. If those third parties, if you sort of de-identify it such that those third parties can't identify the data subjects, is that personal data in the hands of the third party? And the position is generally no. So if the third party was using the data for their own purposes, for their own research, it's not going to be personal data in their hands, as long as it's sort of sufficiently anonymized. Even if in your hands it would be pseudonymized personal data, even if you could sort of work out who was who. So that's helpful because otherwise there's a risk that if you're sharing personal data, anyone in the chain might sort of have to treat it as personal data, even if they've got no idea who the data subjects are. There are two exceptions to this. So if the parties are joint controllers, then both parties need to treat the information as personal data, even if one of those parties can't actually identify data subjects. For example, if a university does a research collaboration with a pharma company, if they jointly write the protocol, so they're joint controllers, if one of them, if only one of them knows who's who, both parties still need to sort of comply with the data protection principles. Equally, if you engage a data processor, and even if the processor can't identify the data subjects, the processor still needs to treat it as personal data, which kind of makes sense to me because otherwise you'll start having processors, suppliers say, actually, I can't, I'm not going to sign up to your Article 28 clauses because, as far as I'm concerned, this isn't personal data. Okay, so next slide, please. Okay, so I just want to share some thoughts on international data transfers. Next slide, please, Evie. Again, the ICO has produced some new guidance on this. It's well worth having a look at. And the Data Use and Access Act has also tinkered with some of the obligations, some of the principles underlying international data transfers. In particular, the the if you transfer personal data overseas, until recently, you have to make sure that the protections in place weren't undermined by the fact it was going overseas. But now the standard is going to make sure that the standard is not materially lower in the overseas jurisdiction. So I would argue that's a slightly lower bar for international data transfers, but I don't think it'll make a huge difference, at least in the short term. And that's because the regulatory framework for international transfers is already so prescriptive. For example, you've got the ICO standard clauses, you've got lots of guidance, but it's certainly useful and perhaps reflects the direction of travel that the government's keen to sort of promote international trade and corresponding data transfers as well. So just to just by way of reminder, the ICO calls international data transfers restricted transfers. The transfer is only lawful if there's an adequacy finding. So if you're sharing data with a country that has adequacy, such as the EU or EEA member states, if there is a safeguard in place with the transfer risk assessment, so typically that would involve using one of the ICO's two sets of standard clauses for international data transfers, the IDTA or the addendum, or if there's no safeguard or adequacy, a derogation, i.e. an exemption applies. For example, if the data needs to be transferred because it's a life and death situation or it's necessary for legal claims. Quite often in an international transfer, there'll be lots of different parties involved, and it might not be immediately obvious which of the parties is responsible for making the transfer legally compliant. So the responsibility sits with the entity that is making the restricted transfer. So let me illustrate that. So imagine that you are contracting with I don't know, a company, an IT support entity in Brazil. Um, uh, they are registered in Brazil. They're Brazilian. That's an international transfer. If you share personal data with them, for example, if they access your systems. If that means that you are responsible for the international transfer requirement, for example, to have the clauses in place and to do the transfer risk assessment. If you're contracting with a UK company and that UK company then subcontracts some of its obligations to a sub-processor, and that sub-processor accesses your data, in that situation, the international transfer is between your processor, your supplier, and their sub-processor, which means that it's your supplier's job to make sure that the transfer complies with the restricted transfer rules. For example, having the ICO clauses in place and doing the transfer risk assessment. Now, whilst that's the case, the new ICO guidance really emphasizes that if your processors if you have a UK processor taking the data internationally, then as the controller, it's still your responsibility as part of your sort of general obligations to do due diligence on your processes to make sure that your processes are making the transfers in a compliant way. So even though you're not directly responsible because it's your data as controller, you just want to have oversight and be satisfied that the international transfers are being done in a compliant way. And then my final point in this slide it's just some thoughts on using the IDTA and the addendum in practice. So these refer to the two sets of ICO standards clauses. The my reading of of the IDTA, the International Data Transfer Agreement, is that it has been drafted to be signed as a standalone agreement, as opposed, for example, to being a schedule to the main commercial terms. But the new ICO guidance has confirmed that you can still have it as a schedule or incorporate it into the main commercial terms. So you need to sort of have it as a separate standalone agreement, which is great. Um, the If the terms are separate, though, I would just make sure that they align with the main commercial terms. For example, I've seen a few cases where the main commercial terms might, for example, limit your liability or exclude your liability. Then the parties sort of forget to copy across the limitations and exclusions to the IDTA or the addendum. So make sure, for example, that anything in the commercial terms that you want to benefit you under the IDTA comes across to the IDTA or the addendum as well. And equally, make sure that the commercial terms and the data protection terms don't contradict. The IDTA or addendum, whichever one you use, must take precedence over the main commercial terms. So make sure there's nothing in the main commercial terms that would contradict that. Okay, next slide, please. So I just want to finish off then with some thoughts on data protection related complaints. Next slide, please, Evie. So as we've touched on previously, data protection complaints are pretty common. Subject access requests, data protection issues are often made in the context of other things going on, whether that's a grievance, a claim, whatever it might be. And so people will inevitably complain. They will complain to yourselves, they might complain to the Information Commissioner. In its most recent annual report, the ICO said it received, I think it was over 40,000 complaints in the previous year. That's an awful lot. Where I see things going wrong with data protection complaints, my sort of top tip here is I would, if someone makes a complaint, I would sort of, where you can, respond once and then just sort of refer back to that each time the complainant seeks to reopen the same issues. Because I sometimes see sort of clients get sort of sucked into this sort of endless cycle where a complaint will be made, they'll be helpful, they'll provide a detailed response, and that simply leads the complainant to make further complaints, generate further lengthy correspondence. So I would say wait to say once, and I would also have in mind that when you're responding to a complaint, you are really writing the complaint, the response, as much for the eyes of the ICO case officer as you are for the complainant. And I would try and set out your position in such a way that anyone who was unfamiliar with the matter would be able to fully understand your point of view, e.g. the case officer coming at this fresh. And if you do a good enough job at that stage, it may be that the ICO doesn't even get in touch because they're kind of satisfied that you've dealt with things appropriately based on your response to the complaint, to the complainant's initial complaint. So the Data Use and Access Act introduces a new requirement to have a complaints process. As I mentioned, this is one of the few compliance areas that are still to come into force. So the new rules come in on the 19th of June. You'll be obliged to acknowledge receipt of the complaint within 30 days, take appropriate steps to respond to the complaint, and then inform the complainant of the outcome of the complaint. So taken as a whole, it doesn't seem to be a particularly onerous obligation, and it really is a light touch requirement. I mean, you've got 30 days to even acknowledge the complaint. So it's fairly light touch. The new rules say that you may wish to have a complaints form, for example, but there's no obligation to have one. So fairly light touch. And I think this is actually quite helpful because it kind of, I guess, forces us to sort of have a much more structured approach to dealing with data protection complaints. So I think it's certainly for some organizations, it will So create a clearer pathway, a clearer point at which the complaint can sort of be sent off to the ICO. So I think that's actually quite helpful for some organizations to have a bit more of a structure to how they manage data protection related complaints. You will need to update your privacy notice and your subject access request templates to signpost the right to make a complaint. So there's no harm in doing that now, even though the new provisions aren't in force for a couple of months. Um, Finally, I would just always make sure that you're thinking more broadly when you have a data protection complaint. For example, we advised in a matter recently where an individual had brought a complaint, data protection related complaint, but it also qualified as a sort of as a whistleblowing um, uh, issue under employment law. So just make sure that you're aware of any of a sort of complaint avenues, any sort of contextual points that might mean you to treat it more than as being simply a data protection related issue. Okay, next slide, please. Okay, so that was everything that I wanted to cover off. As I mentioned, we've got a bit of time for some questions. I'll just have a quick look. Oh, that's great. So we've got plenty of questions. Just give me one moment. Great. Okay. So how do we deal with increasing amounts of requests that are asking for access to metadata, access logs, audit trails? Do we have any grounds to refuse such requests as excessive? Um, if we are talking about subject access requests here, then yes, absolutely. It goes back to what's reasonable and proportionate. I would also query to what extent metadata uh, is indeed the requester's personal data, because quite often it won't be, or indeed it'll be personal data of someone else. For example, if the metadata shows that a colleague in HR worked on a report at 9 o'clock at night, um, uh, then that is not the requester's personal data. That's the personal data of essentially of the HR colleague who was dealing with that matter. Has the response to the consultation on the cyberbill ransomware payments been published yet? Or any updates have been released? As far as I'm aware, the government published the results of the consultation last September, I believe, and there haven't been any updates on the ransomware point since then, as far as I'm aware. Would you please share details of the cases referred to at slide 10? I'm guessing that's the freedom of information slide, but we can certainly include details of those when we follow up with the slide. So Evie, if you can make a note of that, please. Thank you. Surely research is considered part of the university's core functions. Legitimate interests would not be applicable in this case. Yes, absolutely. So as I mentioned, if you're using personal data for research purposes, I would avoid consent. Instead, the options are usually legitimate interests or public task. If you're a university, then it's very likely that the research is going to be part of your core functions, but it is subject to sort of to a charter. And if, for example, I know lots of universities sort of have research spin-outs, and it may be for those spin-outs that the author bases might be legitimate interests rather than public task. Okay, with regard to SARS and a reasonable proportionate search, do you have a view on whether metadata counts as personal data? That sort of repeats the first question, and as I mentioned, I think often metadata simply will not be the requester's personal data. Sometimes it might be. So the way I would look at it, I guess, is threefold: is what's reasonable and proportionate? Is the requester's personal data? Even if it is it exempt? For example, is it personal data about someone else? Um, On SARS, what is the obligation in terms of the form in which information must be provided to the requester? Do you need to share documents containing personal data, redacted as required, or can you provide, e.g., a summary of the personal data that you hold? So that's a great question. Um, so the answer is the obligation is to supply the personal data and not the documents in which the personal data subsist. So that means that it's perfectly lawful to extract the personal data and put that personal data into, say, a separate document or a separate table and share that. And that's often best thing to do if the alternative would be sharing sort of a document where 95% of it has sort of got sort of black redactions to it. The um, I'm always slightly cautious about saying provide a summary, even though that's kind of what it is. So it's not so much a summary, it's an extraction of the personal data. But sometimes it might be that in practice you're providing a summary, but that would only be where you're still satisfied that what you've summarized contains all of the disclosable personal data. Um, for example, if there's a HR matter or a student matter where the information is very heavily mixed. For example, a statement might say both individuals were sanctioned under the disciplinary policy. You might sort of if you share that you're at risk of sharing the personal data about the other person. So you might say, for example, in square brackets, name of requester, and then have the rest was disciplined under the policy. So start complaints process acknowledged within 30 days without undue delay, but no long stop date to deal with the complaint. Do you have any advice for this? And if you should specify a long stop date for responding to the complaint within your policy or leave it vague without undue delay? It's an interesting question. My preference, if it was me, is I probably would specify a long stop date, but I would make it very clear that it's something that you would aim to do, as opposed to being something that you're fixed to, so that you can sort of buy yourself a bit more time if you need longer to manage the complaint. And I would keep it flexible as well. So this is all new for everyone, and so I would be reviewing your complaints process after a month, after 3 months, and just make sure that it works for you, and that it gives you the flexibility that you need to manage the complaints with the available resources that you have. Um, Academics will tell us that they are pseudonymizing to send to third parties, but how do we contractually ensure we are protected if they fail to fully de-identify? So it's an interesting question. So if they are your academics and you don't, and it's not properly de-identified, then I guess the starting point is that the risk is with yourselves. But you can, for example, just what the question is hinting at. So you could, for example, have a contract clauses in your contract with a third party that says essentially it's up to you to be satisfied, the recipient, that the information isn't personal data in your hands. Let us know if you think it is personal data, and we can resend it. You can have contractual provisions that contain restrictions on how they can use the data. For example, they can't publish it, they can't make it publicly available. So there are lots of contractual provisions that you can include just to help manage the risks if it turns out that you've shared information that qualifies as personal data. But the emphasis is very much on sort of the whose hands test. So is it personal data in the hands of person X? So they're probably best placed to make a judgment about what's personal data in their hands. So I think on that basis, it's reasonable for you to put in your contract provision requiring them to let you know if they think it's personal data in their hands. If I'm transferring personal data to X university company and they will not receive the key to re-identify data subjects, do I still need to include data protection terms? If the recipient is an international institution, should we include the international data transfer agreement? So just conscious of time, I'll make this the final question. If If you're joint controllers, then you need to treat it as personal data and include all the usual provisions, including the international transfer clauses. If you're satisfied that it's not personal data in their hands, then you don't need to do so. Okay, so let's bring that to an end then. I hope that was helpful. And again, thank you very much for your questions. That's really great. And it certainly makes things much more interesting for me. And I hope to see you all soon.